Hi, everyone. Welcome to today's virtual Hinckley Forum. My name is Tiffany Chan, and I will be the forum host for today's conversation. The Hinckley Institute of Politics is a nonpartisan institute at the University of Utah. The Hinckley provides an array of transformative experiences for students through internships, forums, and classes. Hinckley forums seek to foster public discourse and civil debate on the most current and pressing issues, bringing in local, national, and international thought leaders. Today's forum is presented as a part of Constitution Day at the University of Utah. We would like to thank our media sponsor, KCPW, for recording and rebroadcasting our forums as a part of the Hinckley Radio Hour. Today's forum is Social Media and the Free Speech Rights of Students. We are joined by the panelist, Professor Ronell Anderson-Jones, who is a Lee E. Teitelbaum Endowed Professor of Law at the S.J. Quinex College of Law and an affiliated fellow at the Yale Law School Information Society Project. If you have any questions, please enter them in the YouTube chat. And so with that, I will turn the time over to Professor Anderson-Jones.
Thanks so much, Tiffany. Hi, everyone, and welcome to our Constitution Day Forum on social media and the free speech rights of students. I'm Ronell Anderson-Jones, and as Tiffany said, I'm a law professor whose work focuses in this space, exploring the tensions between free speech and press rights on the one hand, and how they push up against other values. And my scholarly work considers especially the ways that our longstanding doctrine in these areas maps onto the changing media and communications landscape. Constitution Day, which we're commemorating here today, marks the signing of the US Constitution on September 17th, 1787. And I think today's topic is a really great one for Constitution Day because First Amendment law has become such an important and topical discussion point in constitutional doctrine. It's a timely, critical issue for you to be thinking about right now. And issues of social media dynamics in particular are at the center of some of our most important thinking about the complexities of free speech and the vibrancy of our democracy. Now, we're going to spend the bulk of our time today, sorry, just making sure you can see that slide, focused on a big case that was decided just a few months ago by the United States Supreme Court, in which the highest court in the land asked and answered for the very first time some questions about what the First Amendment rules will be when public schools levy consequences against students for expression that those students engage in on social media while they are off campus of the public school. It's the case of a cussing cheerleader, and I think that you'll find it both a fun situation to try to think through and a great example of how the courts work to develop constitutional interpretation in an incremental way. Our goals will be to first explore what the court has told us about the contours of student First Amendment rights more generally. That is, what the doctrine looks like in this area overall. And then second, to understand what those rights might mean for students, teachers, and school administrators going forward in this new media landscape that we now inhabit. And as you'll see, the court has given us some broad guidelines that will be considered as it weighs future cases involving public school students and their social media use. But there are surely going to be additional complexities that arise as the media terrain changes and develops, and as additional fact patterns present legal challenges that we haven't yet anticipated or that the court hasn't yet answered. So part of what we want to understand here are the big picture, major principles that are at play and how the court has suggested to us that it might weigh them. I especially want to make sure that we have some great interaction and dialogue and debate amongst ourselves. So we're going to make sure that we leave some good time for comments and for questions from all of you, because this is an area where dialogue and debate are really key to our understanding of the doctrinal contours. Okay, so here's our roadmap. Let's talk first for a minute about the First Amendment protections for public school student speech more generally. coming to understand the foundation, the rules that we already had before the United States Supreme Court took on this new social media dynamic in its most recent case earlier this year. We'll get the big basic rules about free speech under our belts, and then think about especially what might be unique about free speech when the setting at issue isn't governmental regulation more generally, but rather is governmental regulation in the context of a public school setting. Then we'll turn to the facts of the case that has just been decided, which is called Mahanoy Area School District versus BL. And we know because she has made herself public that the BL in this case is Brandy Levy. We'll see the ways that this case that Brandy brought to the Supreme Court forces us to think in new ways about the boundaries of our old rules, and we'll consider the best arguments for and against the cheerleader. And then we'll talk finally about how it came out, hearing the answers that we got from the court, the holding that it reached in this specific case, and the ways that it answered and in some ways did not answer questions about how to deal with things that might come up in the future. And lastly, we'll round things out with some conversation as a group, questions and comments from all of you who are participating. All right, let's start with the basic constitutional rules here. The First Amendment's free speech clause, broadly speaking, protects us from governmental punishment for the content of our expression. Now, there are exceptions for sure. It is sometimes the case that expression can be regulated. There's nuance and there are balancing tests that are employed here. And it certainly isn't the case that our free speech rights are absolute. But generally speaking, it's an incredibly strong constitutional value. And we have a constitutional right not to have a governmental entity, whether it's Congress or the president or the state legislature, the mayor, the city zoning commission, having the government take action that abridges our freedom of speech is something that we're protected against by the First Amendment. Now, there are some few examples, extreme examples of speech that is wholly unprotected, incitement to violence, for example, or extreme graphic obscenity. But the rules for deciding when we have those kinds of speech on our hands are themselves incredibly speaker-friendly. So even quite offensive speech, hate speech, profane speech, speech that angrily criticizes government or other people remains protected. And the Constitution prohibits a governmental entity from imposing a punishment upon a citizen for engaging in that expression. We are especially constitutionally leery of what the courts sometimes call content-based restrictions on speech. That's governmental action that punishes you for the actual message or for the actual core of the idea that you want to share. The First Amendment in the American constitutional scheme and framework is based on a notion that democracy is enhanced when government stays out of the business of speech regulation, and a companion notion that is sometimes referred to as the marketplace of ideas. The idea that if one concept or idea is problematic or offensive or wrong, the best response to it ordinarily will be for many other people to exercise their own freedom of speech to counter that idea, rather than for the governmental entity to punish the person who expressed the problematic or wrong idea. Now, for a wide variety of reasons, this doctrine is imperfect and even troublesome. But the baseline of American First Amendment law generally relies on a notion that governmental regulation of speech is going to be constitutionally suspect. And so we proceed with a strong thumb on the scale in favor of free speech. But what about kids in schools? More than half a century ago, these two siblings, Mary Beth and John Tinker, brought a case to the United States Supreme Court that questioned whether these rules that we just described, heavily favoring freedom of speech and heavily disfavoring governmental intervention or punishment for expression, whether these rules would apply at public schools. Now, remember, we said that the constitutional rules apply to all governmental actors, and administrators of public schools are government actors. They work for and represent the government, and they implement government policy at the K through 12 level. The Tinker kids decided to wear black armbands to school in Des Moines, Iowa, in the midst of the Vietnam War as an act of protest to that war. And they did so in violation of a school rule that the principal had enacted after finding out that they were planning to engage in this expression. The rules specifically forbade wearing these armbands, but not other sorts of symbols. And the kids were suspended and their families sued, saying that this suspension violated the First Amendment. The school district pushed back, and it argued to the Supreme Court, yes, we recognize that American free speech is broad under the First Amendment, but schools are different. Public schools are a different governmental setting, a unique one. And the relationship between public school students and their governmental administrators is different than the relationship between other governmental entities and citizens in general. And in the course of deciding the Tinker case, the United States Supreme Court outlined for us some of the unique tensions that inform our understanding of the applicability of First Amendment rights at the public school setting. On the one hand, the court emphasized to us, kids are people too, and public schools should respect the free speech rights of those students as they raise up this next generation of citizens. If we trust the marketplace of ideas outside of the school, they suggested, we should also be trusting it inside the school. Just like adults out in the wider world, students in a public school are going to come from different political and religious and cultural backgrounds. They're going to hold a wide variety of varying views. And school is where we learn to hold those differing views as co-citizens and to challenge our own views and to disagree agreeably. So some form of the First Amendment must apply at public schools. Quoting the court here, it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. But, the Supreme Court said, there are some things that are quite unique about the public school setting and its interaction with free speech doctrine. There is a doctrine, a longstanding doctrine in the law called the in loco parentis doctrine, a suggestion that minor children who are entrusted to the government for its care, the parents sort of have an expectation that the government will look after them the way that the parents themselves would look after them if they were in their care. And when we have compulsory public education and students having an obligation to be there at the school, there's an obligation on the part of the K through 12 public school system to protect minors in the ways that their parents otherwise would. The students who are there in public school are young. Someone needs to be responsible for them. Also, the schools, unlike other governmental organizations, and particularly unlike the government regulators of adult speech outside of the public school setting, the schools are engaged in a particular task. They have a job to do. They have to educate these students during their time there, and they have to protect and look after not just the student who is expressing the student's own views, but also all of the other students who have no choice but to be there and have teaching goals and a need to preserve an educational environment. And so what we get from this watershed Tinker case is the general rule that you don't shed your First Amendment rights at the schoolhouse gate, but also a doctrinal caveat that kids can be disciplined for their speech if their speech substantially disrupts school functions. That is, if what we have on our hands is on-campus speech, then because of the unique features of a public school, the government actors who run these schools can have some broader leeway, are given a broader swath of ability by the court to prohibit or impose punishment for speech that would otherwise be protected if it had happened outside of the school setting. Specifically, the court said that speech that poses a material and substantial disruption to the work of the school can be regulated. So that turns out to be our major question. When there is a substantial disruption of the actual function of a school, a consequence levied against you for your speech is fine. It isn't unconstitutional. But when there isn't one of these substantial disruptions, or when you're not in a school setting, you're fully protected by the First Amendment, and the school is prohibited by the Constitution from punishing you for it. So in the Tinker case, the court applies this standard that it has announced, and it says it was unconstitutional for Mary Beth and her brother to be suspended for their armbands. The school had singled out those Black armbands protesting the war, which was sort of evidence that the school was just focused on the provocative content of the speech, the message or ideas that these student citizens wanted to share. On top of this, the court emphasized, there was no showing whatsoever of any disruption that was expected or that actually resulted from it. Quietly going about your school day with a Black band around your upper arm, it just did not in any way interrupt the school function. It didn't cause the school in its in loco parentis rule to need to step in and protect anybody. It didn't distract from the work of teaching. So it's not speech that the school can regulate. And in the years between Tinker and now, there have been lots of cases about free speech at public school. And under this substantial disruption test, plenty of leeway has been given to public schools to punish or forbid speech in instances where there was a sufficient record of this kind of disruption of the educational process. Courts have listened quite closely to the arguments from school administrators about what was necessary in order to keep the school setting operating in the interest of all learners, and they've tended mostly to defer to school administrators when they had even an arguable showing of actual or anticipated disruption. For instance, in a quite famous case called Morse versus Frederick, the court found that a school could punish a student for a sign that had the sort of nonsensical phrase, "bong hits for Jesus," because it vaguely bumped up against the school's overall school policy against drug use and advocacy of drug use. And in other cases, the court has held that principals or advisors can pull stories from school newspapers and it will still be constitutional, even when it's the sort of thing that would absolutely be unconstitutional if a government entity did it to a newspaper out in the wider community, because the court has recognized there is a pedagogical function in the journalism program at a public school, and that's different. It's a special setting that has this leeway rooted again in the need not to substantially disrupt these school functions. Okay, so our first learning goal here is achieved. And we can see that the general principles in constitutional law are that public school kids have First Amendment rights, and they can't be punished for their speech unless it causes a substantial disruption to the school environment. But disciplining kids for speech can be constitutional when there's a showing that their speech does substantially cause that disruption to the school functions. But now comes the hard part, the plot twist that required the Supreme Court to come back to the issue and give more guidance in the case that was decided just this past term. When the Tinker case was decided, those were, in many respects, the easy days in terms of school speech guidance, because school speech was physically at school and off-campus speech was clearly not at school. And in the new media landscape, things are much more complicated. We now live in a digital communications environment in which students speak to each other in a wide variety of ways that are not rooted in physical presence with each other, but still might be about school or directed to other students or influencing the school environment or in some other way giving rise to a situation that the school feels like it needs to regulate as a part of its broader educational mission. And we can see that from the experience that we're having right now. This forum is taking place digitally from different physical locations. We're all coming together at the University of Utah, but many of us are not physically there. And this dynamic is also the case in the K through 12 situation. It's increasingly the case in the K through 12 situation. And the fact that this case emerged at the height of COVID-19 lockdowns, where a large number of the country's K through 12 public school students were receiving their entire education remotely, put it into particularly sharp focus. So we had this set of questions that the court really had to tussle with. What will count as quote unquote on-campus speech or off-campus speech, when most speech between and among students, and a lot of speech that is to and from and about the school and the school population, now takes place through social media apps, through text messaging, through email, and through Zoom and other digital spaces. How far, in other words, does this special zone, where schools have this special leeway to regulate to avoid substantial disruption to the school's mission, how far does that special zone extend? All right, and so the so-called case of the cussing cheerleader helps us start our doctrinal thinking on this. The case arose when this girl, who's pictured here with her pom-poms, 14-year-old Brandy Levy, tried out for her high school's cheerleading squad and didn't make the varsity team. And on a Saturday, when Brandy was not on school property, but was instead at this gas station here called the Cocoa Hut convenience store, she's there with a friend. And she went onto social media, the Snapchat app, and she posted a picture of herself and this friend with their middle fingers raised. And she included a caption which read, and I'll clean the language here in the same way that the lawyers arguing before the Supreme Court did, but I'll emphasize that the full vulgarities were used by the teen in her snap. F school, F softball, F cheer, F everything. All right, so posts on Snapchat, they're called snaps, are only seen by the account holder's followers. And Brandy had only about 250 of these. The snap would disappear after 24 hours, and her teachers and her cheerleading coaches weren't in her follower group. But another cheerleader took a screenshot of the snap and showed it to one of the cheerleading coaches. And then the coaches got together and met, and they determined that these communications that Brandy had engaged in while she was there in the Cocoa Hut using the app violated the team and the school rules. And Brandy was suspended from the team for a year. Brandy and her parents sued, arguing that this suspension was a violation of Brandy's First Amendment free speech rights. That is, the government entity had punished her for the content of her speech. And to be clear, outside of the school setting, this use of profanity or a use of this gesture, although we could have an argument about whether it's particularly valuable speech, and the Supreme Court here notes that it doesn't think that it's particularly valuable speech, nevertheless, it would be wholly protected. It is not constitutionally acceptable for the government to punish you for engaging in this kind of speech outside of the school setting. If the mayor made a law saying that people would face some kind of consequence for using cursing language to speak ill of others or of organizations to which they belong, or to use the gestures that Brandy and her friend used, that would clearly be an unconstitutional ordinance. Brandy was engaged in constitutionally, ordinarily protected expression. But the question for the courts here is if the outcome will be the same when the regulating entity is a public school and the speech is about a school activity. And we can imagine the tug and pull of the competing arguments here about whether in our modern era, speech like this should fall within those special First Amendment rules that are applicable in public schools, and the school ought to be able to punish you for this kind of speech when it thinks it's disruptive to the school community. That is, that the geography of being physically in a school building no longer makes sense as the dividing line, and the court needs to give the schools some leeway to regulate beyond that geography. The school district argued, in fact, that the new media landscape has blurred the distinction between on-campus and off-campus speech in ways that ought to allow it to regulate speech that is directed at the school and that disrupts the school environment wherever that speech originates. And its argument was rooted, at least in part, in the strong need that the school said that it and other schools have to deal with disruptive harassment and discrimination and bullying. And in fact, at least half of the states have laws on the books that require schools to deal with these issues even when they occur off campus. So we have important First Amendment questions here about whether the First Amendment rules were really about the school environment physically itself being special, because schools are responsible for students when they are at schools, or whether it was about some broader set of responsibilities that the schools have. The competing arguments here are, of course, that it might be dangerous as a First Amendment matter to extend the power to schools to punish students for speech that geographically takes place off of campus. And we saw in the briefing to the United States Supreme Court, lots of arguments being made about the risks of having a constitutional rule that discourages students from saying anything ever that school authorities might deem controversial or critical or politically incorrect, or in any sort of way able to be labeled disruptive and therefore punishable by the school district. So, for example, some of the briefings suggested that students under too expansive of a rule would be able to be punished for posting photos on Twitter complaining about the lack of masks or social distancing in hallways during the COVID era, or for Instagram posts that were criticizing other students for their racist messages. Does giving the district the power to regulate everything on social media that is arguably disruptive or problematic in any way to other students really open the door to broad censorship by school authorities and giving them the chance to reach into the full lives of students? Okay, so those are the contours of the debate. And here's the outcome. By a vote of 8-1, Brandy, the cheerleader, wins this case. The court agrees with her that her one-year suspension from the cheerleading team violated the First Amendment. But she wins in an opinion where, in the course of laying out the new guidelines on this, the justices ruled that the First Amendment does allow schools to regulate at least some student speech that occurs off campus. The path forward that the Supreme Court took on this leaves us without perfect doctrinal precision and with some interesting tensions in some places where public schools want to regulate expression that takes place off campus. I can see places in the judicial opinion where the court is trying hard to continue to leave space for deference to school administrators on some of these extracurricular regulations. But there is also some pretty powerful language that the court wants to keep schools from being able to control what students say 24/7. And I think we can pretty easily see the ways that students will be able to bring the next wave of challenges in this area. The Supreme Court's opinion in this case is really engaging in what we might call constitutional incrementalism, a one step at a time approach to the really vast set of fact patterns that could potentially emerge as students engage in expression in the digital era and as schools regulate the off-campus social media speech of their students. What this means is that we got the answer for this particular fact pattern, but that the court saved for another day the specifics of how it will answer slightly different fact patterns. It gave us instead some broad general principles to think about, rather than firm rules about what speech schools can regulate and what speech they cannot. And this means there will unquestionably be a next wave of cases testing these boundaries. Let's take a look, though, at what we do know from the Supreme Court. The extreme position in both directions was rejected by the court here. The court refused to adopt a hard geographic line between at school and away from school speech. That is, it refused to say as a flat rule that those special characteristics that give schools additional license to regulate speech will always disappear when the school regulates speech that takes place off campus. That is, it's accepting that in this new media landscape, the school may sometimes have a substantial interest in regulating some student communication, even when it's not happening at school. And it specifically named at least some of those interests: severe bullying, harassment that targets particular people, threats that are aimed at teachers or students, the failure to follow rules having to do with lessons or the writing of papers, or the use of school computers or participation in other online school activities, and breaches of school security devices. When any of these sorts of things are happening, the Supreme Court has suggested that rule, that more generous, governmentally generous rule, allowing the regulation of speech and the punishment of speech by the government is going to be permissible. And the court hinted that it might also count as on-campus speech, that is, speech that has different First Amendment standards, allowing the school to intervene and regulate to prevent substantial disruption of learning-related activities, or protection of those who make up the school community. A set of other kinds of spaces where that might still count. All of the times, for example, when the school is responsible for the student, even though the student might not physically be at the school, if they're engaged in speech activity at a time when the school is responsible for them, then that would probably be regulable under these softer standards. The schools, when the student is speaking in the school's immediate surroundings, the court said that might be the case. When they're traveling to and from school, speech that takes place over school laptops or school websites or during remote learning, something that people were especially interested in having the court think about and answer in this new era of remote learning during the public health crisis. The court also hinted that it might take into account the fact that the school needs to regulate speech that takes place during activities that are taken for school credit, which could be a broad array of various activities, and communications to school email accounts or to school phones. And importantly, the court said, and this is a quote from the opinion, it may be that speech related to extracurricular activities, such as team sports, would also receive special treatment. Now, that's a pretty fuzzy statement, and there are lots and lots of questions that school administrators and advisors in K through 12 programs have about how broadly this principle expands, whether it extends, for example, to codes of conduct that some schools, some public schools have implemented, saying things like, if you want to maintain your position on the soccer team or the volleyball team, or if you want to continue to be involved in student government at this school, you have to observe this code of conduct. And if you behave in ways that are unbecoming of a school leader, let's say, then we can suspend you or prohibit you from participating in those programs any further. If that code of conduct extended to speech that the school found offensive off campus through social media formats, then it might draw some significant parallels to the kinds of things that were happening in Brandy's case. And we see the court using that sort of hedging language. It may be, the court says, that speech related to extracurricular activities such as team sports would receive this special treatment. It's laying the table for additional litigation to come and for cases in the future that might have to test exactly how far these boundaries extend. But the court also goes out of its way to say that it doesn't want schools to feel like all speech everywhere are within its unique regulatory power. It gives us three big features of off-campus student speech that it says should make us feel like it's less likely that schools will have an interest in regulating that speech. Firstly, the court says that students' off-campus speech will generally be the responsibility of that student's parents. Remember our in loco parentis doctrine, protecting and guiding the children that are within the government's care. When they're not in the school's care, the court is suggesting it will leave it to parents to decide what is appropriate for their kids to say, and it won't be the role of the court to intervene and punish that speech. Second, there's an explicit recognition by the court in this opinion that if schools could regulate all off-campus speech that in any way implicates the school community, this would cover virtually everything that any modern student says or does outside the school. The student would be under the thumb of the school 24/7. And the justices make it clear that they think this isn't an acceptable First Amendment dynamic. Quote, that means courts must be more skeptical of a school's effort to regulate off-campus speech. For doing so may mean that the student cannot engage in that kind of speech at all. And you see a special sensitivity that is happening here on the court's part when it comes to political or religious speech that occurs outside school or a school program or activity. The court says, will have a heavy burden to justify its intervention. There's a concern that expanding the school's power to regulate all social media would leave the student without any opportunity to engage in that important speech that's so critical to the conversations that we're having. Thirdly, the court tells schools, you have to keep in mind that you also have an interest in protecting unpopular speech and ideas by your students. The court is emphasizing again this marketplace of ideas notion and suggesting that kids deserve to learn at a quite young age that they can take strong views in opposition to others in their community and they can still be protected. The court said, we can see that Brandy Levy's curse-filled rant here isn't speech that was particularly thoughtful or maybe even particularly valuable. It was an angry string of vulgarities. But the decision to suspend Brandy Levy for her snap violated the First Amendment. The court stressed that if she had been an adult, Levy's speech would normally be protected by the First Amendment. Citizens are constitutionally protected in their choice to use foul language. And the court here says, America's public schools are the nurseries of democracy. They're the place where you learn how to speak with other people, how to respond to speech by other people, and what your relationship is vis-a-vis your speech and your government. And so it's important to the court here that that be kept in mind when regulation of off-campus speech is on deck. Importantly, the facts of the case here really influenced the outcome for the court. Brandy created the snap off of school grounds on a weekend. There was no evidence that it had caused the kind of substantial disruption that would justify her suspension. The court acknowledged that some people might regard the substance of Brandy's snap as being sort of so trivial that it's not the kind of speech that's worthy of First Amendment protection. But here's the language from the court in the opinion. Sometimes, the court said, it is necessary to protect the superfluous in order to preserve the necessary. So if we tear down the rules and say that the schools rather can punish you for things that they dislike you saying or things that they find offensive, it might be a short step toward them labeling as quote unquote disruptive lots of things that just don't align with the majority viewpoint, but that ought to be protected. And the Tinker case made clear that this isn't something that the First Amendment allows. In fact, the court emphasizes, the First Amendment exists primarily to protect those whose views are out of alignment with the preferences of the political or religious or cultural majority around them. Because if what you have to say is something that the majority likes and favors and approves of, you can still protect yourself through the legislative process and through the fact that the people holding positions of power probably approve of your expression and won't punish you for it. The First Amendment protections come into play when someone is saying something that the majority finds problematic. So we don't get perfectly clear answers from the Supreme Court in this case about every situation. And in fact, we get a lot of sort of maybes and perhapses, but the court in deciding Brandy Levy's case does take a big, important step into the 21st century in recognizing that there is a new media and communications terrain, and that this terrain does require us to interpret First Amendment principles in new factual scenarios, and that it will require public school teachers and administrators in particular to think about that balance between free speech and avoidance of school disruption in some new ways with some new guideposts. And in the meantime, Brandy Levy gets the satisfaction of knowing that they could not kick her off of the squad for dropping her F-bombs on Snapchat. Okay, so thanks very much. It's been a treat to be with you this afternoon. I want to make sure that we use our remaining time for discussion. So let's open things up for comments or questions. Okay, our first question here is a question about how things, how the terrain, the legal terrain and constitutional doctrine might differ if we are thinking about the K through 12 public school setting and if we are thinking about the university setting. The Tinker Doctrine is specific to the K through 12 setting and grants particular leeway to the government to regulate and to punish speech in that space, in part because of the in loco parentis doctrine, which doesn't apply at a university setting. At a university setting, the speakers who are being regulated by the government aren't minors. They aren't people who have been entrusted, children who have been entrusted to the government for the government's care, but instead are adults who are interacting with the government in an adult setting where they're making their own decisions about their well-being and about their speech patterns. And so although there are at least some doctrines that extend into this space, including a parallel doctrine in the journalism front that we described, where regulation of, for example, student newspapers in that space might be treated differently than non-student speech more generally would be treated. It definitely is the case that the government has significantly greater regulatory leeway when it's regulating K through 12 students and the speech rights of K through 12 students because they're presumed to be minors. Okay, let's another question here. Sorry, can you see? Okay, if the court refuses to list all exceptions, will we keep on anticipating even further controversies of free speech and students because public schools still have the discretion? Yes, so that's an astute observation, and it's an observation that is true about constitutional doctrine more generally. What we see, particularly from the United States Supreme Court, when it is asked to articulate the scope of constitutional doctrine in a particular area, it often answers the question that is directly presented to it, the facts that are directly presented to it in a particular case, and then saves for another day the broader answer to questions of facts that are slightly different from that set of fact patterns. The court does so for a number of reasons. One reason that it does so has to do with larger doctrines of separation of powers and the court's own sense of its own role in our constitutional scheme. The courts are unelected. They, unlike the executive and legislative branches, don't have accountability. They're not majoritarian institutions. They're designed not to be majoritarian institutions. There's a goal of having them act as a check on those other two branches and hold accountable those other two branches to make sure that they're behaving in ways that align with constitutional principles and constitutional rules. But the court is very sensitive to the fact that it doesn't have the power of the purse, and it doesn't have any armies. It doesn't have any capacity to enforce its own doctrines, but rather only has its own goodwill and institutional legitimacy to continue to have its rulings in these spaces observed. And so as a broader principle, the court is often tries to exercise this kind of judicial restraint, where when it's presented with a question, it answers the question that it is asked, which was, could the school regulate Brandy Levy in this way, consistent with the First Amendment? And it tries to give some guideposts as to the explanation for why it reached the conclusion that it did. Brandy Levy's situation had these particular traits. And so we know that if a speech regulation, an off-campus speech regulation, shares those same traits in the future, it will be treated similarly. But it also tries to give us, you see here, some broader guiding principles that help us know and help school districts know going forward how they can craft their solutions. We might suspect that the court is particularly leery of handing down a very clear list of what kinds of social media dynamics are regulable and what kinds are not, given the fact that the social media and broader communications terrain changes so rapidly. Speaking factually to a set of facts that exists in one moment of time isn't necessarily in the court's best interest or in the population's best interest, because those fact patterns in sort of a boots on the ground way might really be shifting over time, and the court doesn't want to lock its doctrine to a particular set of communications assumptions that might change over time. So instead, what you see when you read the opinion in the Levy case is the court trying to speak more globally, speaking not specifically about how Snapchat works or specifically about how communications by students in this moment in 2021 operate, but rather about sort of first principles, the kinds of things that make us err on the side of more or less protection from First Amendment regulation in the public school setting, and how those guideposts might happen in the future. For sure, I got lots of calls after this case came down, asking questions about fact patterns that seem pretty obvious that still need to be resolved. The question, for example, about how we would treat codes of conduct that regulate the speech of extracurriculars, students who want to participate in extracurriculars. The court doesn't speak squarely to it. And what that will mean is that there will almost certainly be additional litigation that will happen down the line. The case that was just decided will provide the guiding precedent in the area. And then in subsequent cases that are not exactly on all fours with this cheerleader's case, but instead have slightly different facts that might be slightly more persuasive for the courts to find on behalf of find in favor of the school districts in those areas might come out differently. Okay, let's see. When students, let's see. How does free speech apply to students with differing political opinions to their professors, such as giving a student a bad grade on a paper because they don't agree with the student's opinions? Yes, okay, that's a good question, and it's a question that is captured in First Amendment doctrine, separate and apart from the Brandy Levy fact pattern. The First Amendment rights of students in schools, in public schools, are despite the doctrine that we just described about substantial disruption, are broad and fulsome. Students have the rights to hold their views, and professors have the rights to hold their views. And students have the right not to be punished by their government for holding the views that they hold. And so that would that would be the case in a curricular setting, and that would also be the case equally in the same way that it would be outside the setting. Now, a professor can hold you accountable for for expressing a position that is inaccurate as a curricular matter. You may not argue as a free speech matter that you have the free speech right to hold the view that 2 + 2 = 5. You don't have a First Amendment claim to be made there, but you do have a First Amendment right to not be punished for the content of actual viewpoints, your political or religious views or otherwise. And there are lots of cases that emphasize the rights of students to be able to express views that are contrary, that are counter-majoritarian, that are not held by the other members of the class or not held by the professor. And those implicate the First Amendment rights of students. Okay. If a student posts about public school staff or official negatively, would this blur into the lines of defamation of character? Yes, the overlaps here are interesting ones. There's a broader set of doctrines that take place here. So let's imagine that Brandy in her snap, instead of just sort of using a vulgarity to say some vulgar things about the team and the cheerleading coaches or the cheerleading program, as she did, had instead made up a lie about the cheerleading program, or the individual cheerleading coach had disseminated a defamatory falsehood about the cheerleading program director. In that area, there is an extra layer of First Amendment doctrine that comes into play. And this is true not just for students, but also for the population at large. The First Amendment is implicated in defamation law, and particularly when the statements that are made, the allegedly libelous statements, are made about somebody who is a public official, a person who is in charge of overseeing governmental programming in a particular area, or a public figure, a person who's thrust themselves into a public conversation or has fame or widespread notoriety in a particular area. Those people have a tougher time bringing libel claims than ordinary private citizens in conversations that aren't on matters of public concern. And the court has said that's important as a First Amendment matter, because we need to be able to have vibrant conversations about public officials and public figures, and because public officials and public figures have lots more opportunities to be able to counter that speech with truthful speech. So if something false and defamatory is said about them, they can access the mechanisms of counter speech and can convey truthful information out into the marketplace of ideas and have the resolution sort of preserve their reputation by speaking out truthfully rather than by suing for libel. There's also some suggestion from the courts that those folks have kind of voluntarily assumed the risk that there will be conversation about them, and that might include the risk of defamatory falsehood. The doctrine in this area is more complicated than we have the time to get into, but it definitely is the case that if the facts here had been tweaked and the things that the cheerleader was saying were not just offensive, but rather rose to the level of meeting a claim for defamation, the First Amendment contours might have changed. Yep. Okay. Other questions? Let's see. Okay. When students petition to repeal a school's action of censorship or discipline, is this considered free speech? Where would this petition be in this discourse? Okay, yes, that questioner highlights something that's important about the layers of free speech that happen here. one of the ways that a person who feels that they have been inappropriately censored by a governmental entity, whether a public school or otherwise, might express that is by bringing a complaint about it in the next instance. And there are at least some cases in which there are layers of First Amendment concerns that are designed. So if individuals who feel that their First Amendment rights were violated bring action and then feel that they were retaliated against for the highlighting of that initial censorship, you might have a second layer of First Amendment litigation that takes place, a layer of concern that they were retaliated against for the exercise of their First Amendment speech rights. And in those contexts, one, of course, does have the right both to express oneself in a public school and not be punished by the government for that expression, and also the right to bring attention to that fact, to speak about that in those ways. Indeed, Brandy didn't need to have made her case as public as she did. You see from the header in the case that she's protected because she's a minor. Her name is not listed in the case caption as an ordinary course of things. Brandy and her parents made the case public and spoke broadly about it, in part because they thought it was an important matter of public concern, that it was the sort of thing that ought to be discussed widely, and that implicates, and in fact does implicate, millions of public school students across the country. Lots of folks were watching quite closely to see the outcome of this case for Brandy, because these fact patterns are becoming more and more common as we move to a situation in which a lot of the communication that happens amongst public school students within the same school, the ways that you are speaking to your fellow classmates, the ways that you're speaking about your fellow classmates, conversations that you're having about the school curriculum, about school activities, about the school administration, and vice versa. Much of the school's communication to you is now often happening in a space that isn't physically the school campus, the school building. And so there were lots of answers that were anticipated, eagerly anticipated by lots of folks in the K through 12 setting, to try to sort of get a handle on how we take that old doctrine about First Amendment rights in the school setting and apply them to this new factual dynamic. Okay, let's see. We have time for one more question. Oh, and maybe we don't even have time for one. We'll answer it quickly. Okay. Can free speech be subpoenaed or used as evidence by courts that may be contributory to illegal activities or crimes? Yes, that's another important sort of piece of First Amendment doctrine. Remember, we said that First Amendment rights aren't absolute. We have a heavy thumb on the scale for suggesting that one has First Amendment and free speech rights in a particular area, but there are instances in which the compelling governmental interest on the other side of the equation is strong enough that if the government tailors its request for that information in a specific enough way, it will overcome the free speech rights. And some of those settings include you have a right not to be compelled to speak, but you also don't have that right in a subpoena setting, because the countervailing interests on the other side of that, including somebody's right to receive a fair trial and the interests of justice in an individual instance, overcome the right that you have not to be compelled to speak. Okay, I think that's all the time we have. Is that right, Molly? Tiffany? Great, excellent. Thank you for joining us today. Take care, everybody.
Thank you so much.